today to this panel discussion on Indiana's public defense system. I'm Rebecca Green, and I'm the news director at WBOI, your local NPR station. And with me here today is Mr. David Carroll. He's the executive director, Mr. Carroll. He's the executive director of the Sixth Amendment Center in Boston, and Mr. Larry Landis. He is the executive director of the Indiana Public Public Defender Council. And Allen County Chief Deputy Prosecutor Mike McAlexander is on my right, and Allen County Superior Judge Fran Gall is on my left. Today's discussion about the status and health of Indiana's public defender system is brought to you by IPFW's College TV, WBOI FM, and the Mike Downs Center for Indiana Politics. So we're going to start today by talking about why we need or have a public defender system. Mr. Carroll, could you explain to our viewers and listeners what the basis is for public defense?
Certainly. So anyone who's too poor to afford a lawyer and is facing a possible loss of liberty at the hands of the criminal justice or juvenile delinquency system is under our Constitution required to have effective assistance of counsel at every critical stage of those proceedings. Now, I think where a lot of people have a misconception is they think this right starts in 1963 with the Gideon versus Wainwright decision. But the right to counsel goes to the very core of who we are as Americans. What most people don't realize is at the start of our country that the English system specifically prevented lawyers from being in courtrooms. And whereas most of the Europeans that came to our country were those that were subject to religious persecution, they were not going to stand for that. And so the start of having lawyers defending people goes even before the founding of our country here. In fact, when the Bill of Rights was created, the people who drafted the Constitution was not going to allow the government to take over someone's liberty without the process being fair. It fits in with all the other anti-tyranny portions of the Bill of Rights. And so even before the Constitution was adopted, the federal system required attorneys for anyone facing a capital case. And of course, back then, almost everything was a capital case, horse thievery and things like that. And so where almost every state beyond the original colonies is cut up out of federal territories, the right to counsel really starts even before statehood for most states, and certainly that's the case in Indiana. And so I think what people don't realize is when Gideon versus Wainwright came around, the vast majority of states were already providing counsel to the poor. It was really just those states that come out of the Spanish and French heritage as opposed to the English heritage across most of the country. And so I think when people think of the right to counsel, they mistakenly sometimes think of it as just another liberal civil rights decision of the Warren Court, when in fact this is the core of who we are, an anti-tyranny versus individual liberty country.
Thank you. Your Honor, does Indiana have similar requirements in its Constitution?
Actually, we do. I mean, in our Bill of Rights, Article 1, Section 13 requires that anybody charged with a criminal offense has the right to be heard by himself and his counsel, therefore implying that they have the right to have counsel appointed if they're not able to hire their own attorneys. So yes.
To you gentlemen, does the system in Indiana clear up some of the practical applications of the constitutional requirement? Is it easy to do here or not in Indiana?
Well, it's never easy to do because it costs money to do and it takes political will to do. And because Indiana throws that responsibility on the backs of counties, that means it's county officials that have to fund it. And so if you look at a state like Indiana where we have a property tax cap, the revenue sources are very limited. So when you go for money for public defenders, you're competing against much higher priorities of elected county officials. They've got to fund police and fire pensions. They've got to take care of the roads. So when you're trying to compete with those funding needs for money for providing lawyers for people accused of crimes. It's difficult to persuade local funders that this should be a high priority.
Go ahead.
Well, I was just going to say that, I think to the public, they recognize police departments go with the appropriate entity, but most of the criminal justice system is paid for at the county level. And frequently, we've all heard county officials bemoan the fact that 72% or 75% of their budget goes to criminal justice, which includes the jail, the Allen County Police Department, prosecutors, public defenders, and the courts, as well as a juvenile center. So that's a lot of money every year.
Your Honor, if you're arrested in Indiana, how does the public defender system work? What happens from a practical standpoint? And you need a public defender. What happens?
Well, you come into court at your initial hearing and you indicate to the judicial officer that you are unable to hire an attorney, and we appoint counsel for you based on your eligibility. Most of the counties, Allen County particularly, uses the federal poverty guidelines. So household members, 4 household members and a certain amount of income and a certain amount of expenditures is looked at to see if you qualify for a public defender. And that's conducted, in our county at least, it's conducted, there's an investigation that's done by an investigator to determine folks, their financial status, and then we appoint counsel for them.
Is that decided by the judge decides if a person needs the public defender? That comes from that investigation, then the ultimate decision relies with the court?
We do. We appoint public defenders, at least in Allen County. They're appointed pretty much by default, subject to their eligibility. And they have to sign paperwork under oath indicating what their financial status is, and if they own property, if they have any kind of real estate or stocks or bonds, or any kind of family ability to scrape together money to find an attorney.
From a prosecutor's perspective, what is the benefit to the system if you as a trial attorney for the state is facing a competent and qualified public defense counsel?
Well, I think the public perception is that we want somebody who's 6 months out of law school that we can roll over. The reality is, and I learned this very early in my career because I handled the post-conviction relief cases, and that was primarily a review of people that had been convicted, but to determine whether their due process rights had been followed through and whether they had received effective assistance of counsel. So early on, I discovered that even though you might be able to win at the trial court level, if you didn't do it right or the other side was unarmed in a sense, you were going to have that case sent back to you. So the thing you didn't want to have was having to try the case twice, because by the time you got it back, you would lose witnesses, it would be harder to prosecute it. So it really instilled a sense of, let's do it right the first time, and that requires competent counsel on both sides. And I've had cases where I've had concerns about opposing counsel being kind of out of their league. And it's one of those things that I think for the good of the system, you want a good opposing counsel. Even though it may be tough, it may make your job a little tougher on the front end, but it does provide a better sense of justice.
The system works better when there's a fair fight.
Yes.
When it's a fair fight.
If
Well,
I
it's
may
also-
piggyback onto that, our experience in state after state that has addressed this issue is that the prosecutors are often one of the first to come on board for reform, and we appreciate that. When I interview prosecutors, and indeed when I interviewed prosecutors here, a number of them said to me, we're tired of being the ones trying to preserve the record. We're doing extra work trying to make this happen. And conversely, in many states, the last people arguing against change are the actual public defenders that are currently working in the system because they figured out how to put food on their family's table under the current system. So I appreciate the prosecutor's words. I agree wholeheartedly with them.
I can say as a judicial officer, having an equal level playing field with very good attorneys on both sides makes it so much easier for the fact finder, whether that fact finder is a judge or whether that fact finder is a jury, that you get competent representation on both sides so that the fact finder's job to find the truth is much easier.
Larry?
No, I totally agree. I think defense lawyers would say the same thing about prosecutors. They'd much rather be paired against a very competent, experienced prosecutor because inexperienced prosecutors don't know how to evaluate the case. They don't see the weaknesses. They might overestimate its value. A good, highly competent prosecutor is going to see their strengths and weaknesses. And most 90% of cases are resolved by plea agreement. So the more that you have experienced, competent lawyers on both sides, they can evaluate the case and they know whether this is a triable case or not a triable case. And so you avoid those trials that should not be going to trial because there's no triable issue. And you get a fair, appropriate resolution when you've got two good, competent adversaries. And it's really important to remember that in an adversary system, the whole system relies upon the quality of those advocates because the judge only sees what is presented to the judge. The judge doesn't go out and evaluate and investigate the case. So if you don't have two good, competent lawyers working the case, you have a much higher chance that either you're going to have an error on guilty people going free or innocent people being convicted. And I think that's why we want two good advocates. You want to reduce the error rate on both ends.
Who in Indiana, we kind of talked a little bit around this, that it's a county service. The counties pay for it. Are all counties providing this service? How is it structured in Indiana?
Well, all counties have the burden of providing and funding indigent defense services, and that was placed upon them in 1854 by a case in the Supreme Court where the case came up as to how are we going to provide and fund this, where the judge said, I'm going to provide counsel. Who pays for it? And the Supreme Court, it went straight up because the county council or the county auditor said they weren't going to pay. So it went up to the Supreme Court to resolve it, and the court said, well, the county pays for the cost of the jail and the cost of prosecution, so I guess it must be on the backs of the counties that they have to pay for it. And we still are operating under that 19th century decision of it's a county responsibility. Half of the states have gone the other way, and now, after Gideon and Argersinger and there's a right to counsel has expanded, they've designed statewide systems to say this is a state responsibility, we need to step up, we need to provide a highly competent and effective system for delivering these services and find a funding mechanism. Indiana's not done that. So that's part of what this whole effort with the task force is we're looking at the whole system and saying, is there a better way to provide services that you get higher quality and more cost effectiveness?
Indiana's in the vast minority of states that don't fund 100% of indigent defense services. Earlier I mentioned the Gideon versus Wainwright case. The importance of that case in my mind is that it's not just a Sixth Amendment case, it's a 14th Amendment case. And what the court says is that the state holds the obligation to provide effective representation. Now, they've never been asked whether that state can pass that obligation on to local governments, but what we do know is that if a state chooses to pass that on to local governments, the state is still responsible to ensure that the counties not only can do it, but are in fact doing it. One of the major flaws of Indiana is that there's absolutely no infrastructure to evaluate whether that's happening or not. So in your state, there's well over 300 courts which have attorneys providing Sixth Amendment services. And for most of the existence of the Indiana Public Defender Commission, they had one person as a staff. How they expect to evaluate over 300 courts with a single person is beyond me.
Where does the money to pay for that in other states come from when they kind of consolidate, so to speak, under
the
the
majority of
state?
states, it's a straight general fund appropriation from the state that goes through the regular budgeting system. The reason for that is that the counties that are most often in need of indigent defense services are the ones with the least ability to pay for it. So if you think about it, the same indicators of a poor economy, high unemployment, low graduation rates, those things are also usually the same indicators of crime. And so I know when the Sixth Amendment Center went across the state, the team that went to Scott County in particular was saying they just can't ever do this given their low revenue stream, and they have high drug issues and mental health issues and others. You can't really blame the counties. They're trying to do what they can with what they have. They don't have enough to do it, and so it really needs to be from the state.
Mr. Carroll's kind of opened the door a little bit to talk about some of these inconsistencies throughout the state. I know in my own work as a journalist covering a number of smaller communities, you would see differences in how it was handled, how in the competency of the attorneys that were hired. What have you observed through the state, and this is kind of for the three of you?
Well, I think Larry probably knows the system the best simply because different counties handle it different ways. We have a local board that is in charge of the public defenders, but a lot of counties, and I think some of the smaller counties, the individual judge hires the public defender, or they have a board that hires and does contract type of thing. Most of our public defenders in Allen County are considered county employees and receive a benefit package similar to the rest of them. But we have 92 counties, and I think my guess is if you really look at all of them, we probably have 92 different systems.
In those 92 counties, does that stereotype of the ineffective, the attorney asleep at the witness table, at the defense table, does that stereotype exist, or is every defendant in Indiana getting fair representation?
It exists as a stereotype, whether
Does
it's
it exist in
perpetuated by
reality?
TV. Well, I think to a large extent, public defenders get a bad rap because it's perpetuated on TV. Mm-hmm. There's a lot of problems with the quality of representation, but it's not because they're bad lawyers. I mean, if you look at everything that impairs quality, you'd say, well, lack of independence is important. If you're an at-will employee of the judge, that's going to impair your ability to be a strong advocate or to ask for the resources you need because the judge is telling you, we don't have any money. If you absolutely, really, desperately need it, come and talk to me. So they self-censor. They don't go ask for the resources they need. If you get too many cases, I don't care how good you are, you're not going to be as effective as you need to be. So you look at the systemic issues that impair quality, and that's what we're trying to address in this task force. It's not the lawyer's fault. If you got too many cases, you don't have the resources, you have inadequate compensation and you're part-time, you're not going to do as good a job as you would if you had all of those resources. And the other thing, you need some quality oversight. Somebody needs to be assessing quality because we have to remember this is a constitutionally mandated service. It's required to be provided. The consumer, the client, has no choice on who the lawyer is. They can't fire the lawyer. So you don't have any consumer choice, and you've got somebody providing it and nobody overseeing quality. So you're going to have, anytime you have a system like that, you're guaranteed to have some quality.
I will say, Larry, in Allen County, if I get a letter from an individual who's got a public defender and that individual is complaining about their public defender, they don't get to choose the public defender that they get. But when we get complaints about representation, we notify the chief public defender in our county and we demand an investigation. And that public defender investigator goes to the jail or makes an appointment with that client, and they talk to them, and then they report back to the court. And I have removed public defenders because there have been conflicts between the defendant and the attorney that cannot be reconciled, and then we will appoint a new public defender for that individual.
Yeah.
And it's common practice for us as well after a trial, if an individual wants to appeal their conviction and their sentence, that we give them a different public defender for purposes of appeal so that the new attorney can look at the trial attorney and see how was that handled at the trial level. So we do to an extent.
I appreciate that in Allen County, but we have 60 counties
exactly
without a chief public defender. We've got 30 counties where they're at-will employees of the judge. So, I mean, those are the ones we've got these systemic problems where you don't have quality assessment, you don't have a chief overseeing it. You've got, in fact, we just had a public hearing on last week where one of the public defender board members from down south said, I've been on the board for 20 years, we have 10 part-time public defenders. I can tell you nobody oversees quality. We meet 4 times a year, we're volunteer board members. That's just not a system that is set up to maintain high quality or even to monitor the cost effectiveness. We've got problems on the other end. We've got lawyers who are appointed case by case, for example, and they can run the meter without anybody, calling them and say, you're not providing cost-effective services. You're just, you're billing for things that aren't being done, and nobody oversees that. So that's why we've got to redesign the system and say, if you're going to have a system of providing this kind of volume of services, you have to have quality control, and you have to have cost-effectiveness control, and you have to have somebody monitoring so that you have consequences for providing bad representation. That's another flaw we have. There's no consequences, really, to anybody for providing really poor quality representation to an individual. There's malpractice is not an adequate remedy. There's really no discipline when there's an ineffective assistance to counsel. The courts aren't liable, the county's not liable, and the state's not liable. So you can get away with providing bad representation and nobody's accountable. That's a flawed system.
But back to your question about the stereotype, at least in Allen County and in the 30-plus years I've been here, we have had some of the best trial lawyers in the community on the public defender staff. And more than once, I know the judge and I have laughed when we see somebody hire private counsel that does not even compare to the quality of representation they will get from the assigned public defender. Because we have folks that when people, friends, family ask me, who would you recommend as an attorney? It's frequently somebody who's on the public defender staff that I would recommend. And if I was ever in trouble, that's who I'd go look for.
So Allen County's blessed.
Yeah.
They have some very good, competent, qualified lawyers, which makes me, when I hear sometimes on TV you say, the clients will say, I don't want a public defender, I want to go hire a real lawyer. And we say, you got the real deal. You already got it. You just don't know it. So yeah, the public defenders get that rap as somehow they're second-rate lawyers. They're not second-rate lawyers. They might work in a second-rate system that impairs them from being highly effective, but it's not because they're hired and they're bad lawyers.
It's hard to beat the stereotype of the guy on My Cousin Vinny.
Right.
But his cross-examination was excellent.
Brilliant.
The public defender, though, was kind of...
Oh, yeah, him. Yeah.
So
Vinny was good.
one of the reasons that we're here today is that Mr. Carroll's organization put together this really thick and informative evaluation of Indiana's indigent services. And I'd like for you to talk a little bit about that, if you can. Is this unique? Have you done these for all 50 states, or are you just getting going?
We have not done it for all 50 states. The Sixth Amendment Center is 6 years old. Okay. I've been doing this in one form or another for 20-plus years. And so I've done this in probably about 10 to 12 states, and then several large counties as well. What I'll say is that Indiana, to me, the level of services lives on a very wide spectrum. You've got very good systems in felony areas, particularly in some of the large urban areas. But I think that the main problem is that the state has institutionalized and legitimized the choice not to meet the Constitution. By letting counties opt out of the Indiana Public Defender Commission, they're basically saying, if you can do it cheaper without our reimbursement, go for it, no matter how low those services can get. And I think a lot of county commissioners and managers, they're not constitutional scholars. They don't know necessarily what's required. I've said that what I find very troubling about Indiana is the level of justice someone receives very much is dependent on which side of a county line the crime is alleged to have been committed. And more importantly, the level of justice they receive may very well depend on how the prosecutor charges it. If it's a felony, they may get decent representation. If it's a misdemeanor, they're more than likely not. And misdemeanors are very important. Even though the jail term might not be as long as a felony, the life consequences from a conviction are very great. Person could lose professional licenses, which will lead to losing their job. Even a short stay in jail may result in a breakup of the family, and then you bring on all sorts of other court costs for figuring out who gets kids and different termination proceedings and other things like that. And of course, someone very well could get deported too. And so this idea that, you know, misdemeanors aren't really that big a deal is just something that's very, very seriously flawed in this state.
Among your findings, you've said that Indiana's system is fragmented, and we've kind of touched on that before, and you know, depends on what county you're in, with a lack of oversight. Again, we've talked about that a little bit, and a system without adequate funding. Is that anything else that we're missing in a summary of your report?
Well, I think one of the things we touched on is sort of the roles of judges, and the concept of independence of the public defender is one that, as Sandra Day O'Connor says in Strickland, is constitutionally protected. When we talk about judges overseeing systems, I think sometimes a lot of people think, oh, we're saying judges are bad people that are trying to, you know, ruin these clients' lives. I don't believe that at all. I've traveled all across this country, and I think 95, maybe even higher % are just good people trying to do good jobs. The problem is when a public defender contracts with a judge, the public defender internalizes what they need to do to please the judge to get the next contract or the next appointment. So it doesn't take a judge overtly saying in a courtroom, don't file any motions in my courtroom, I want to be on the golf course. It's not that. The public defender internalizes and says, oh, well, things are going okay. I'm not going to rock the boat much because it's more important for me to get the next contract than to do what I'm ethically obligated to do for my clients.
Mr. Landis, are these fair criticisms of Indiana's system?
They're more than fair. I mean, the adversary system requires that you have two independent adversaries, neither beholden to the tribunal before whom they advocate. Our system doesn't have that. We've got one of them dependent upon their income from the judge. That's just not a sound system, no matter how good the judge is. I agree totally that it's the public defenders have that chilling effect and if you think about many trials, when you go up on appeal, what you're alleging on appeal is the judge made a mistake, the judge made an error. That's your boss. You know, that's not a healthy system. Nobody would design a system that way intentionally, saying this is a really good, sound adversary system where one of the advocates was hired by the judge. I think if the judge hired prosecutors, everybody would go, well, we can't have that. Or if the prosecutor hired the judge, we couldn't have that.
Great idea.
But so why is it okay for the judge to hire the public defender? You know, and it just happened by default. I mean, it happened because there was not a system designed to provide counsel. So it arose under the inherent authority of the trial court. That was the only place to put the responsibility. It's just that in 160 years, we haven't rethought a better system. And so now that's what we're trying to do, is say there's probably a better system. We don't have to destroy what we got. We can build on the structure we have. We just have to fix some of these structural systemic problems that we have.
Allen County has had some issues with misdemeanor public defense in caseloads. Would this report apply in that area?
Oh, absolutely, absolutely. And not just in misdemeanor courts. We've got this fragmented system across the state of the city and town courts as well, where you have oftentimes judicial officers that aren't even lawyers, that are adjudicating cases and sending people to jail without benefit of counsel. I find that horrifying. And I was on a committee for many, many years that we've been trying to get some legislation passed to abolish the city and town courts and just to absorb those cases within the superior and the circuit court system, because it goes against all reason that you have people that are not lawyers adjudicating cases and sending people to jail. But you've got that happening all across the state, and these are folks that have no benefit of a public defender. There's no attorneys that are coming in to help these folks. So
I think as far as the misdemeanor aspect of it, again, I think we're all supportive of quality representation for anyone who's charged with a criminal act that can result in incarceration. I think where it gets a little more difficult is in the details of it. When we went through this this past fall with County Council approving additional public defenders for the prosecution, one of the standards out of the Public Defender Commission is that they ask that public defenders be paid pretty much the same as prosecutors. And but they apply caseload limitations in their standards as well that don't apply to prosecutors. So, for example, last year we had roughly 6,000 misdemeanor case filings in Allen County. Well, we run that with a staff of 3 or 4 generally younger deputy prosecutors and 1 supervising attorney. And sometimes, like right now, we've only got 3 full-time attorneys. They looked at hiring allegedly 6 full-time attorneys to do that. Well, in addition to the cases that get filed, we also have to review all the other stuff that gets submitted that we don't file. We have to read the cases enough to create plea agreements to tender, as well as be in court for every case. So we're doing everything plus, as well as preparing cases for trial. And being a prosecutor is equivalent to being the director of a play. You've got to get all the actors together, bring them in, make sure they understand their roles, and make a cogent presentation to a jury. So we're doing a lot of things, and I'm not sure that sometimes we don't get sideways with each other because some of the standards seem a little arbitrary to us. And I've certainly had conversations with felony deputies that are getting paid the same doing murder cases and child molesting cases. Their caseloads may be lower, but they'd say it would take me less time to do 1,000 misdemeanors than it does to do 75 or 100 major felony cases. So somewhere in this, I think if we want to do it, we need to have a more realistic approach to misdemeanor offenses and what it takes to do those acts. Because I think one thing people forget is misdemeanors are not whodunits in the same way that a lot of felony cases are. Because other than domestic battery cases, nearly every misdemeanor is committed in the presence of a police officer. So it's a little bit different investigation than a neighborhood dispute or where there's no obvious witnesses around.
Mr. Landis, thoughts on that?
I don't disagree. I mean, I think the issue is if prosecutors think they have too many cases, then they should be making their case for these are too many cases for us to do this responsibly for the public safety and the public good. But to say that public defenders' caseload shouldn't be raised as an issue, I don't think it doesn't hold water with me, because the standards that the Public Defender Commission has adopted have been studied for years, and they really track and model the national standards and the ABA standards. So they weren't just made up by the Commission for Indiana. These are national standards, and the roles on cases are quite different on misdemeanors. The public defender has a duty to independently investigate the case, and they don't have police officers who go out and can investigate. And when they try a case, a misdemeanor, all they have to do is put a police officer on the stand and say, and then what happened next, officer? And then what happened next? Public defender has to have independently investigated that case and gone out and done some work outside. So the workload on a public defender on a routine misdemeanor case is far different than a prosecutor. But I'm not saying they aren't overloaded. They may well be. I just am not as familiar with their workload or their standards. And if they are, I think they should be making a case, because I think what we agree on is the criminal justice system as a whole is underfunded, seriously underfunded. And we have to take a look at that, because if the public wants high quality justice, then the whole system needs to be invested properly. And we've got problems on both sides of prosecutors and public defenders being put into major felony cases way too soon, way before they're ready, in part because the turnover is high, because you've got students coming out with a $120,000 debt load. They can't afford to be public servants as deputy prosecutors or public defenders for very long before they have to start paying that back. So we've got a crisis looming in the criminal justice system that needs to be addressed, because otherwise we're going to have inexperienced people on both sides trying major felony cases, and that's not good for the public. either side. You got guilty people getting off, and you got innocent people being convicted. And we can't afford to have high error rates before you start losing public confidence in the system.
So just hearing, you're talking about prosecutors have this problem with their caseloads that needs to also be addressed potentially. And it's hard to get county councils to want to fund that.
It takes a long time. I mean, I'm not saying that they won't, but historically they are reluctant to add additional employees to the system.
Right. So the biggest limitation is money.
Well, it always comes back to money, I think. But I do think that there are differences in how you have to handle the case. And the one thing that the defense has in terms of investigation is their client knows whether they committed the act or not. Once it's explained to them so that they understand what is against the law, they know whether they were drunk when they were driving. So they can short circuit that, and they frequently will ask not to have the whole thing investigated, but they'll ask, what's the best deal you can get for me? So every case doesn't require massive investigation. I would agree on the cases that are potentially either legally insufficient or have factual disputes. We should have public defenders that are able to go in and adequately investigate those. But I don't think we have to treat every case like it's a major felony, because it's not that complicated, and the offender wants to move on with his life. If he knows he's got to do 60 days in jail, he'd rather do it and get going. So I think we have to have a little bit of understanding of human nature, who our clientele is. The misdemeanor population is frequently different than the felony population. And because the consequences are lower, they may not be willing to participate in the same level or have the same things at risk. They're not going to prison for 20 years on a misdemeanor. At most, it's a year, and with good time credit, it's 6 months in Indiana. So,
I think one of the important points here is no one wants to build bureaucracy for bureaucracy's sake. We want to uphold the Constitution. Now, if you can scale back the number of cases so that the need for public defenders is far less than what it currently is, that's a perfect solution to this. In other states, we've seen both the far left and the far right coming together and saying, do we really need to be bringing all these cases? You can increase diversion. You can reclassify low-level nonviolent misdemeanors and felonies as infractions. One of the big things I've seen nationally is decriminalizing driving on a suspended license. These are cases a lot of people, they don't pay a certain fee, they don't even know their license is suspended, they're pulled over for a broken taillight, and all of a sudden it's a criminal offense, and they potentially could lose their job and things like that. I think there needs to be some of that. I think what the key theme here is that the way we've been handling criminal justice of locking up as many people as possible has not proven to be either good for public safety nor cost effective. And so I think that's something that I've been very encouraged nationally on, is sort of having both Democrats and Republicans coming together and saying we have to think about this whole process differently.
We have about 15 minutes left in our discussion, and I want to make sure we touch base on the recommendation and what the task force is trying to do. So if you could summarize these recommendations for us and some of the things that your organization has identified as stressors on the system and things that need to change, and then we'll go from there.
The two big pieces to me is that you can't legitimize the choice not to meet the Constitution. So there does need to be a way for the state to set standards and enforce those standards. And there's plenty of examples from around the country, even states within this region, who have similar economic issues. In Michigan, for instance, at the leadership of Governor Rick Snyder, they created a Michigan Indigent Defense Commission that has the authority to set standards, and they've capped the local share of costs at what they were when the legislation took place. Any new monies that have to be expended to meet the standards, that's going to come from the state. And a lot of people were curious if that would actually come through. And just last week, Governor Snyder released his budget, and there's upwards of $60 million for state indigent defense at the trial level. Now, I don't think anyone thinks Michigan is a panacea of riches right now. They took the 2007-2008 recession particularly hard. And so I think there's, I do think that it's possible here. People often ask me, where's the money going to come from? I'm not an expertise in Indiana's budget. My role is to say you've got a constitutional issue, and if the powers that be want to fix a constitutional issue, someone smarter than all of us will find the money. That's been the case in state after state that I've worked in. And so I am encouraged here that there is a task force that involves all three branches of government, involves the counties, involves criminal justice stakeholders, to look at these issues and say, how can we go about changing these things? That's an approach that's worked in state after state. So I remain very optimistic that Indiana is going to be able to settle this. The final piece on the money I just want to bring up is that if it isn't fixed, the only alternative is litigation. And what we've seen, one of the results of the presidential election, no matter where you fall on the political spectrum, is that the ACLU got a lot of donations, and a lot of that money is being spent on this issue. So they're suing California, Nevada, Utah, Washington, Missouri, Mississippi. There's lots of litigation going around about these exact same issues that we found in your state. So it could be that with the task force, with that outside pressure, that the political will is starting to come around to really figure out what's best for the citizens of Indiana on all of these issues.
What are we doing here in the state, Mr. Landis, to try to shore up the indigent counsel system?
Well, when the task force report came, or the Sixth Amendment Center report came out, Public Defender Commission took its time to kind of dive into it and figure out what they should do, and they decided they should put together a broad-based task force with all three branches of government. So we've got the governor's office, we've got Supreme Court justice, we've got trial judges, we've got academics, we've got a great group that is looking at Indiana's system and trying to figure out where are we strong, where are we weak, how do we build on our strengths of what we have, and we have plenty. Actually, we've got a Public Defender Commission with statewide standards. The standards are good. It's kind of a carrot and stick approach. The problem is the carrot's too small, and there's really no stick, because there's no enforcement. There's no sanction for non-compliance with the standards. The county can just drop out and continue to do what they want. So we're looking at how do you fix those, looking at the other states, including Michigan that was mentioned, and trying to figure out are there pieces of other states where we can enhance our system using basically the existing strengths we have, and try to get more state money to the counties, because that's a key, and more oversight, and probably some more independence in the places where we need it. So that's what the task force is looking at. They're now doing, we call it a listening tour, but it's really kind of public hearings going around the state to listen to public defenders, judges, prosecutors, citizens, clients, whoever wants to talk about the system, and hopefully come up with some recommendations for the legislature next year.
What are you hearing on your listening tours, if I may? I'm just curious.
We're hearing, what you would expect, things we talked about. There's a wide variety of systems. Some of the flaws are the lack of independence. There's no oversight, no accountability, no consequences for bad services, inadequate resources, inadequate compensation, excessive caseloads. Those are like the big six. We haven't heard people complain about judicial tyranny.
Mr. McAlexander, what would you identify as something that could improve Indiana's public defender system? You've been in the prosecutor's office for a while.
A little while.
one or 2 days?
I think we're a little spoiled, as I said earlier, in Allen County, because for the most part we have a very high quality group of attorneys. I think when I look out to the future, one of the things that concerns me is that The only way you get trial experience now is in the criminal system. Almost all the civil litigation is going to mediation. It gets settled. They have very few actual trials. So if we want good trial representation, we're going to have to develop the lawyers within the prosecutor's offices and within the public defender structure. And this is one where I do agree. I think that the public defenders have historically been kind of independent contractors, and there are good reasons for that, for conflict rules. But it also, I think, has not given them a sense of identity and purpose together. I mean, they're all like the Lone Ranger dealing with their individual case instead of seeing the bigger picture. And I think that's something that has been institutionalized because they respect the independence of that individual lawyer. Where in our office, we can set plea policies. You know, burglary is going to get in this range.
This is how we do things.
Yeah, but we don't have that among the public defenders. So I think that creates probably some problems of perception of uniformity or the lack thereof. But I also think long term, when I look at some of the people that have been our long-term public defenders, a lot of us are getting rather gray, and in another decade we may not be there, and there aren't a lot of 30-year-old public defenders. We have some younger staff. We regularly recruit folks just out of law school, but the public defenders, I think they've got one on staff right now, and that's the first person straight out of law school that they've had in a long time. So I do think there's some things like that. If we want to maintain even the system that I think is pretty good in Allen County, we're going to have to do some planning to ensure that it stays that way.
Well, and
Judge Ball?
I think to kind of piggyback on that, there's no training. I mean, if you got somebody right out of law school and you were hired into the prosecutor's office, there's training provided. There is no such training component with the public defenders. So you get these kids right out of law school, and they don't even know that when they file a motion, they need to submit an order, that they need to set that motion for a hearing. So a lot of the training is happening in the courts. You know, where they're coming in and they're floundering around, and I feel very bad for them, and they need to be, there just needs to be some kind of formalized training structure to get these folks up to speed so that they can provide high quality, effective representation.
Mr. Landis, we've got about 5 minutes left. I want to give you the last word on public defense in Indiana. And
Well, that's a rare opportunity. The last word on anything.
I want you to kind of identify what you think is maybe the lowest hanging fruit that could be addressed first to make Indiana's public defense system a little bit better.
Well, I think the lowest hanging fruit to solve a lot of the problems would be if the legislature would say that the standards adopted by the Public Defender Commission were mandatory, and all counties must comply. If we're going to stick with a county-based, county-funded system, then we've got to have state standards that are mandatory for every county. You don't get an option to not comply with those quality standards. And then we have to figure out the funding mechanism for what happens if they don't, and how do you do enforcement. Some states, what they have done is to do a county-based system like that, but say, if you continually do not comply with state standards, we will have a state takeover. And then the State Public Defender Commission can appoint a chief public defender or somebody to take over that system, and then hire the right people. And in some counties, we may have to go to a regional system. We've got some small counties that really, they can't even find lawyers. Enough lawyers to provide representation. And so it might make more sense to do some regional representation or regional offices with local lawyers, so you can do the oversight, and you can have some support services. You can have paralegals, social workers, investigators out of a regional office that wouldn't be cost effective out of a really small county. So those are just a couple of the things that I think are doable, and it wouldn't be a radical change. It would just but the mandatory state standards would probably have the biggest impact quickly.
Has there been any movement in the legislature for that, or for any kind of
the task force has not made any recommendations yet. So I think
you're not there yet.
We're not there yet.
Okay.
Probably sometime this summer There will be a report and then recommendations for the legislature in the next session.
Can we fix this?
Absolutely. You know, I've been in state after state, and it almost always starts with, but Mr. Carroll, you don't understand this is, and then fill in the blank of that state. Every state is unique. Every state has to have their own unique solution. Unfortunately, this isn't a, you know, cookie cutter off the shelf model that you just import and say, well, Massachusetts does it this way or Colorado does it this way. It really does have to take in the uniquenesses of Indiana, and I think regionalization in certain parts of the states is probably part of the answer. But I do feel very optimistic that you've got good leadership. Former federal judge John Tinder is the chair of this task force. I've been very impressed with. And the people that are on that task force are really taking this seriously. So I think the citizens of Indiana can be proud of that. And I think you can definitely fix these issues.
I want to thank you all for coming and sharing your opinions and your knowledge, and it's been a really fun discussion, kind of a legal junkie. So I really enjoyed it. I hope our viewers and our listeners do as well. So thank you all for coming.
Thank you.
For
Thank you.
talking with us about this issue.